Imagine this. It's 2:17 in the morning. Your kids are asleep. Your front door explodes open, and officers are in your hallway screaming, "Police, don't move." They never showed you a warrant. Is that legal? Or did they just commit a Fourth Amendment violation in your living room? There is one narrow loophole that can turn what looks like an illegal home invasion into a lawful entry. And if you don't understand it, you cannot protect your rights when police are at your door. Hey everyone, I'm criminal defense attorney Marc Lopez, and today we're talking about the single most protected place in American law, your home. And in the next few minutes, I'm going to break down 3 situations where police can legally cross your threshold without a warrant, 2 situations where they absolutely cannot, but they still try, and the 1 exact sentence script you can say through the door to protect your rights without getting charged with resisting law enforcement. This all comes down to one phrase: exigent circumstances. The only claim justification for kicking in your door without a warrant. And here's the scary part. Police get this wrong all the time. Courts suppress evidence, throw out cases, and sometimes strip officers of immunity when they cross this line. So let's start with the foundation. What the Fourth Amendment actually protects and why your front door is legally treated like a castle gate. The Fourth Amendment protects your house, your papers, and effects from unreasonable searches and seizures. Courts call the home first among equals in terms of constitutional protection. It gets the highest level of respect. As a general rule, police need a warrant supported by probable cause to cross that threshold. No warrant, no entry. That's the default. And the protection doesn't just apply to the drywall and the bricks. The law also protects the area immediately around your home, called the curtilage. That's your porch, your front steps, maybe the little walkway up to your door, and the immediate yard. Police are allowed to come onto that area for what's called a knock and talk. Now, courts say they have an implied social license to walk up, knock once or twice, wait a short time, and then leave. The same exact way delivery drivers have, or Girl Scouts trying to sell cookies at your home. But when officers go beyond that limited license, or when they claim there's an emergency, that's where we step into the doctrine of exigent circumstances, and this is where your rights are most at risk. Exigent circumstances is a very narrow exception to the warrant requirement. It lets officers enter without a warrant only when there is a compelling need for immediate action. The kind of situation where waiting even a few minutes to get a warrant could be unreasonable. Think of it as the emergency override to the Fourth Amendment. You don't get to press it because it's an inconvenience to get a warrant. Now stay with me, because in a few minutes, I'll give you the exact words to say when police are at your door, words that assert your right without turning the situation dangerous. The first pillar of exigent circumstances is preventing the imminent destruction of evidence. If officers already have probable cause to believe there's evidence of a crime inside your home, and they reasonably believe the evidence is about to be destroyed, they may be justified in entering the home without a warrant. Classic example, officers hear toilets flushing, shredders running, people yelling, "Get rid of it!" So don't do that. The key words here are probable cause and immediate destruction. Not a vague hunch, not this could maybe happen someday, but a concrete, urgent situation where waiting for a warrant would mean the evidence is gone forever. The second pillar is hot pursuit. If police are actively and continuously chasing a suspect they believe just committed a crime, and that suspect runs into a house, officers can follow them inside without stopping to get a warrant. This has to be a real chase in real time, not, "We saw him earlier today and we know where he lives." It's, "We're right behind him and he just sprinted through that door." But there is a huge limitation here. Police cannot create the emergency themselves and then use it as an excuse to enter. If officers pound on your door like they're trying to break it down, shout threats, and cause you to panic, they can't then say, "Well, we thought you might be destroying evidence because you were panicking, so we had to go in." Courts call that police-created exigency, and it does not justify kicking in your door. The second core category is imminent danger, also called the emergency aid doctrine. Here, officers don't care about evidence, they care about people. If they have an objectively reasonable belief that somebody inside is seriously injured or about to be, for example, they hear screams, gunshots, or clear signs of a violent fight, they may be allowed to enter to prevent harm or provide aid. This is about safety, not snooping, but they're going to snoop when they're inside. But even here, courts look very closely at what the officers actually knew at the time. Another big factor courts look at is the seriousness of the underlying offense. Judges are very reluctant to excuse a warrantless home entry for something minor. Entering a home because of a felony involving violence or serious danger? Maybe. Kicking in the door over a simple misdemeanor, like an elevated traffic infraction? Courts have often said that's not enough to justify invading the sanctity of a home. Even in cases involving underage drinking, where there might be potential danger, some courts have held you need concrete evidence of actual imminent injury or death before you get to bypass a warrant and go into someone's home. Now, this is where most people, and honestly, a lot of officers, get confused. Just because police have enough evidence to get a warrant does not mean they can skip the warrant and kick your door down. Probable cause answers the question, do we have enough evidence to justify a search? Exigent circumstances answers a very different question. Is there such an urgent emergency that we cannot wait to get a warrant? If police have probable cause but no genuine emergency, they're supposed to back up, go to a judge, and get that warrant. Quick question for you. Before this video, did you think probable cause was enough to kick in a door? Drop me a yes or no in the comments. I'm always shocked at how many people have been misled as to that point. Now, a lot of the worst Fourth Amendment violations don't even come from claimed emergencies. They come from officers abusing the knock and talk ideas. In cases like French v. Merrill, officers don't just walk up, knock, and leave. They come back repeatedly in the early morning hours, pounding on the front door and bedroom windows, shine lights into the home, and yell for the occupants to come out. The court said the behavior by the officers in the French case plainly exceeded the implied social license to approach the door. No private citizen thinks they have the right to wander around your house banging on windows at 3 a.m., and police don't get that right either. Not without a warrant and not without a true emergency. That kind of conduct has been called what it is, an illegal, warrantless physical intrusion into your home's protected area. So what does all of this mean for you, practically, when officers show up at your door? There are two rules I want you to remember. Rule number one, you do not have to open the door. The moment police knock, you still have the right to remain silent, unless they have a valid warrant or clear, provable, exigent circumstances. You are not required to open the door and chat. Your refusal to cooperate by itself does not create an emergency and does not justify forcing their way in. Rule number two, any forced entry must be justified and the search must be strictly limited to the emergency. If officers claim exigent circumstances, they better be able to prove in court that they had an objectively reasonable basis to believe an emergency existed right then and that it could not wait for a warrant. So, what should you actually say, if anything, when police are at your door? If it's safe to do so, and ideally, while you're recording on your phone, you can calmly state, I do not consent to entry or search. I recognize that any entry without a warrant or genuine exigent circumstance constitutes trespass and is a Fourth Amendment violation. You're asserting your rights clearly and non-violently. You're not arguing about the law on the porch. You're creating a record later for court. Now, I do need to give you the most important safety warning of this entire video. Even if the entry is illegal, please do not physically resist. I get it. If someone storms into your home unlawfully, every instinct in your body is going to be to fight back. But the courtroom is where you fight. Your living room is where you survive. If you physically resist, you risk seriously hurting yourself or others and possibly picking up additional criminal charges such as resisting law enforcement. The real recourse is later. Getting the evidence suppressed or pursuing a civil rights lawsuit where the officers can actually lose qualified immunity because the law on home intrusion is clearly established. Remember, exigent circumstances is a powerful tool, but it's supposed to be rare and it has strict boundaries. Knowing those limits is one of the best ways to protect your home and your family. If you have ever had police knocking at your door, share your experience in the comments. Your story might become the next case study we talk about. Now, if you watched this video this long, you must like me just a tiny, tiny little bit. Please like this video, subscribe to my channel, leave me a comment. You can even be like, hey, Mark, this video sucks. I much rather prefer, hey, Mark, this video is awesome. You're great. I read them almost every morning, a couple times a day. If you are facing charges in Indiana, give me and my team a call here at Marc Lopez Law Firm, 317-632-3642. And most importantly, remember to always plead the fifth.